supplementary cost list, item number 1, pronouncement of judgment.
I'll read only the operative portion. I'm afraid this court is of the opinion that you have already been given more than you ought to have got. So I don't think you have the case. It's up to you. So in view of the observation made above, this court is of the view that the petitioner has not been able to make out a case in his favor, and the actions of the respondent Nehu has been justified as far as fixation of the proper pay scale of the petitioner is concerned. As far as the third financial upgradation is concerned, the petitioner, as and when he is due, the Nehu shall process the same expeditiously, considering the fact that this matter has travelled for quite some time before this court. With the above, this petition is disposed of, with the same being rejected, no cause. Hello. Thank you. Correct.
May it please your lordship, I beg to mention item number 18.
Yes, Mr. Nukla.
I'm for respondent number 6. No objection.
You are the person.
My lord,
No
yes,
person.
I'm for the state.
Even at this stage, if you can, settle the matter amicably, it would have been better.
My lord, regarding the settlement of issue, they have to approach civil court, my lord, because it is entirely a dispute between the Durbar and the petitioner, my lord. So far, the state, my lord.
I think, is it a question of compensation?
No, my lord. It is actually the area, my lord, who is to issue the authority, my lord, which they have issue, which they are challenging. So far as the role of the state, that is PW department, my lord, the construction work has been completed, except in the particular area of the petitioner, my lord, that particular stretch we have not covered. The remaining we have already completed, my lord. Because he is, the petition is asking for a certain compensation, which is not proper, my lord, because the entire, this project has been, my lord, funded by the state resources. So it is not, and by the Dorbarshnong and the local landowners who have given their land for their own village. So, my lord, there is no question of compensation, my lord, here.
Dorbarshnong has no say.
My lord, Dorbarshnong
Dorbarshnong is not the owner of the land.
The only thing is that as far as Durbarshnong is concerned, Lordship, I would like to submit that this is the lifeline of the area. So as long as the road is functional, there's no.
Those consideration has to be there. See, if I recall correctly, the petitioner also has no objection to to the road being constructed and all those things, even parting of his land, but it was not done properly, if I'm not mistaken.
No, my lord, he is demanding for construction of a drain as well as the wall, my lord, which is
retaining wall.
We are not even touching that area, my lord. It is just actually leveling of that, but in his particular areas, that stretch, my lord, is only leveling. So we are not even reaching his land. So the land which we are touching, those landowners have given the NOC, they have agreed. So his land has not been even touched. So there's no question of giving compensation to him.
Look, we'll see. But you can still talk, see?
My lord.
How long, miss?
2 weeks, sir.
And why?
Lordship.
Why are you seeking a general?
Your lordship, as the learned DSGI is not, the learned senior counsel is not prepared, my lord, for this matter.
On plea made by the petitioner, or objected to by respondent, matter is adjourned. This is the same after 2 weeks.
Much obliged, Lordship. Similar prayer for item number 9 as well, Your Lordship.
Nine.
No objection, Your Lordship.
On pre-made. I could do. Hold on.
Obliged, Your Lordship. Please, Your Lordship, I beg to mention item number 12 on behalf of Mr. P. Nongbri, Your Lordship.
We have P. Nongbri.
Item number 12.
Yes, here, Mr. Nongbri. Oh, what is this?
Good, no? Yes. So Sujit there is there also, Lordship, is ready.
Oh, he may be there, but you wanted to make a mention?
No, Lordship, by mistake there's a communication gap.
So we'll let him come up. Mr. Hazarika, you are there.
Yes, my lord, I am the petitioner here.
So what is your?
No, I thought of doing, my lord, my friend is ready to, it is better to do. If not, next week, we have to finish.
Because doing but next week.
Okay, my lord, next week. Because my client is bedridden, so before that I want to finish it.
Been reading also, getting it ready.
If you ready, so
Okay,
I will do it. No problem.
Next week, Lordship.
Okay.
Positively.
On pre-made by the parties, let's just matter after 1 week.
What's up?
Lordship, I beg to mention item number 6 of the main list, Lordship.
On week 6, this court has made number of observation. I believe this matter was part heard, isn't it?
Somewhat
It
part
was
heard, but
It
then
was heard for some time, Lordship.
the complainant has already expired, so that
Oh,
was
that
a
doesn't
state.
matter. We have proceeded ahead.
Yes.
It is against the order of the Board of Revenue.
Revenue Board.
And they have chosen not to substitute the person who is deceased. So they want to proceed without being substituted or anything. Anyway, that will be a question of law.
True. We'll take up this matter.
Lordship, senior counsel has some difficulty today, Lordship. Any
take it
day
up, we'll
next
take
week,
it.
Lordship.
Next week. 2015 matter.
Lordship.
I believe happening to the last order. What is the last order? On pre-made by the petitioner seeking adjournment on the ground that the learned senior counsel who is conducting the matter is indisposed. The matter is adjourned. It is, however, made clear that no further adjournment will be given in this matter. Same to be heard definitely within the next date fix.
Lordship.
Parties are requested to make suitable arrangement for the same.
My lord, can I make one small prayer, my lord? Because the case is originally from the office of the deputy commissioner. Then the matter traveled to the revenue board, my lord. I was praying if the record of the deputy commissioner could be called, my lord, because it may be assisting us during the course of hearing, my lord. What was the original complaint? What was the order passed? Order passed is already annexed, but then certain documents which were placed in the record may be available to us for perusal also, my lord.
Well, you don't have the brief with you?
The brief is only the pleadings, my lord. But without the permission of the court, I have not called for the records of the Deputy Commissioner's office.
You should have.
No, my lord. On my own, my lord, without the leave of the court.
No, you should have made a prayer of this sort a long time ago.
No, my lord, because that stage of hearing has never come, and it did not occur.
My lord, if at the stage of hearing at that point comes, my lord,
then if it is required, we can call it at a subsequent date
of
also.
time also, my lord.
But
Yes,
that
if
may
it is
be,
required,
Yes, my lord.
that option will be out there also.
this is matter after 1 week.
Alright, beg to make a mention of item 10 of the hearing disorder. My lord, here I am to produce a list of the district council schools, my lord. Schools which have been taken over by the government. So, my lord, I require a little more time. My lord, this is the second round of litigation. What I had submitted before this honorable court on the last occasion was that in the earlier round of litigation, my lord, we had filed a very detailed affidavit also giving the list of the schools which were taken over by the district council schools which were taken over by the government, my lord. So, my contention was that the petitioner school was not one of the schools taken over, my lord. So, my lord, I require little more time, my lord, to...
What is the case about, Mr. Momin?
This is in respect of the old pension scheme, my lord.
Oh, the old
That matter, my lord. So, I'll require little more time, my lord, to get that list. What's your...
How long?
Well, I'll pray for 2 weeks at least, my lord.
Mr. K.P. Bhattacharya, learned GA, appearing for the state respondent, has submitted that he would require some time to seek specific instructions which would be relevant at the hearing of this matter. The prayer not be objected to by the petitioner, the same is allowed. As prayed for, this is matter after 2 weeks.
My lord, I'll oblige, my lord.
Please, your lordship. Lordship, I beg to make a mention item number 8.
So 2020 matter.
My lord, Lordship, senior counsel is having some personal difficulty, your lordship.
In this case also, my lord, certain observations has been made earlier also that the matter should be taken up on the next date fixed.
Yes, because you see the old matters, and as this court has observed from time and again that these old matters, by the time they are finally disposed, they have become, some of them have become infructuous. It's like an appeal, a criminal appeal, where the sentence is 7 years, and at the before the 1 month before the 7th year, it is disposed of, or 1 week. What's the point?
Operation successful, my lord. Patient is dead. That is a saying.
My lord, if I may pray next week on Friday, your lordship, as per senior's instruction, your lordship.
We will not give a specific date. We have to
be next week.
We'll have to look at the board. On prayer made by the UFR.
Respondent, your lordship.
Prayer made by the respondent. Not objected to by petitioner. Matter is adjourned. Discussing after 1 week. And be sure next date we'll do it.
Yes.
Again, what else?
Item 15, your lordship.
Last chance has given, my lord, in this case.
Lordship, senior counsel is suffered leg injury, your lordship, so I prayed that it may be listed on Friday, your lordship. This coming Friday, your lordship.
I do, again, I've made it very clear. This court will not fix dates, because if I fix a date, I know that on that day you will still ask for it. This is...
In this case, my lord, maybe some observation may be made, my lord.
Observation has been
No, my lord, because I may be allowed to join in the school, so they will not take time if you suspend of order. Otherwise, they are delaying all the times this and that. So
The
after last month
Adjournment,
also taking time.
once again, prayer is made on behalf of the petitioner, review petitioner, seeking adjournment on the ground that the learned senior counsel is indisposed. This prayer has been objected to by the learned counsel for the respondent, Mr. A.H. Hajarika, learned counsel for the respondent, who has submitted that observation has been made by this court in previous orders that this matter should be taken up definitely on a next date fix. However, though no strong objection has been made to the prayer made for adjournment, the learned counsel would submit that definitely on the next date fix the matter should be taken up. On consideration of the submission made, the prayer for adjournment is allowed. However, the review petitioner is to pay cost of 5,000. The same to be paid in favor of the Meghalaya State Legal Services Authority. Failing which, matter shall proceed. Good out of this is matter after 1 week.
My lord, I beg to mention item number 60 with the consent of the senior counsel appearing for the petitioner. My lord. Item number 60. My lord, here we have difficulty for the day, my lord. If matter can be taken on some other occasion.
I think this matter was heard substantially.
My lord, yes, it was heard.
It was heard substantially. Because the only issue here, my lord, is whether notice is required to be served on the private respondent. That was the only. Let it come up next week, my lord, because I may also withdraw this in view of the recent decision of the Supreme Court, which says that even after acceptance of the FR, the complainant can still file an petition before the magistrate itself. So perhaps by next.
Do it now. Do it now. I said withdraw it now. Why would you?
I just need to see instructions from my client. Let it come up next week, my lord.
Material instructions for all we know. On prayer made by the parties, this is matter after 1 week.
Apply charge.
May I please, your lordships, there item number 17. So it may be taken next week, my lord, on next Monday or any other day next week.
See, Mr. Jarika, let me tell you, these appeals,
Yes.
if they are not taken up, within this next 1 or 2 weeks,
Yes.
I will not take it up, in the middle of
1 week, my lord, after a
middle
week.
of December, I will not take it up.
After a week, my lord, I will try to finish next week, my lord. Only some ruling I am yet to
How
get.
many cases have been fixed for next week? On prayer made by the appellant, this is matter after 2 weeks.
2 weeks.
Please, your lordship, I beg to mention item number 11. The learned counsel, Mr. Pugin, is not keeping well, your lordship.
The learned counsel, Mr. Learned counsel for the petitioner has submitted that the learned conducting counsel, Mr. P. Uvin, is not keeping well and could not appear in court today to take up this matter, for which adjournment is sought for. Any objection?
My lord, MBCL is also a party here.
On the same that be
Respondent 2 and
objected
3.
to by the respondent, matter is adjourned. This is after 2 weeks.
Much obliged, your lordship.
From daily cause list, item number 1.
May it please your lordship.
May I please, your lordship? And we're supposed to file the strong objection Some more time, Lordship. And put the respondent number 3, Lordship.
What about this respondent 1 and 2?
I'm for responding 1 and 2, Your Lordship. Requires some more time, Your Lordship.
You have not filed yours.
No, Your Lordship. Requires some more time, Your Lordship.
Item 1 and item 5 both are connected matters.
Yes, Your Lordship.
Item 1 and item 5.
Same parties.
Yes.
You appear for?
The petition. Issue is same.
The issue is same.
There too the prayer has been made for response to the. Have you filed an application for or made a prayer
Similar application for
for deleting the name of the learned counsel for the respondent 1 and 2 respectively, as well as the learned counsel for the respondent 3 have submitted that the response to the prayer made by the petitioner for deletion of the name of the respondent 1 and 2 from these proceedings could not be filed today, and as such some more time is sought for the same. On consideration of the prayer made, the same is allowed. Let the said response be filed within the next date fixed. List this matter up to 2 weeks.
Similar prayer, Your Lordship. Similar prayer for item number 5, Your Lordship.
Same order.
Much obliged, Your Lordship.
Item number 2.
Yes, have you filed your affidavit of service?
Yes, sir. I have already filed and given to the parties concerned.
My lord, the affidavit which we have received, my lord, one missed case has been received, my lord, here from the petitioner, my lord. Here, my lord, the application says an affidavit to take steps upon respondent number 1. Respondent number 1 is state, my lord. So we have been appearing from day 1 when this matter was listed. They were supposed to take steps upon respondent number 3, that is Mecofed.
Yes.
So, my lord.
2, 1, 2,
1
and
and 2
3.
is state, my lord. So Registrar of Cooperative Societies is also a state body. So we are already representing 1 and 2. So 3 is the respondent upon which steps were required to be taken. So my lord, the application says that this is an affidavit to bring on record steps taken upon respondent number 1, which is
1 and
1 and 2.
2 and 3 also.
No, my lord, the copy which have been given to us says 1 and 2.
This
No, 3 also is there.
No,
Managing
we have
Director.
Maybe, my lord, they have not given us that copy. We have received the copy which have been served upon us.
but where is the
This is the copy.
This is the copy you're
Yeah,
giving us.
this is the one. Here is there. Number 3, the Managing Director, Meghalaya State Corporation.
where is it?
Lumdinggiri.
Where
Last
is-
down portion, number 3. Page 1. Sir.
Which one of what?
Page 1 of this affidavit, sir. And they have received also.
This copy has been received by the council.
My lord, I'm for 1 and 2. my lord.
Yes, 1 and 2.
and
Where you have already. Who's appearing for?
My lord, they have a standing counsel, Mr. P. Obin, for Mecofit. So I believe if notice have been served, he should
Some time ago, it was
Yes,
mentioned that he is not
junior
well.
colleague has appeared for one of the matters. So I'm not aware, my lord, why they have.
His colleague was here.
I believe, my
You
lord,
wish to
notice has been served to the
you wish to
office.
respond to this?
No, my lord, we may not be required. Mekofet will be required. They are the main contesting parties. So far, we have senior counsel is appearing as instructed, and we will not be filing any affidavit to this application.
Heard Ms. S. Rahman, learned counsel for the petitioner, who has submitted that the affidavit of service as regard the issuance of notice upon the respondents 1, 2 and 3 in particular have been filed with this court. Ms. Arkulni, learned J, has submitted that the respondent 1 and 2 have all along been appearing in this matter. However, none has appeared on behalf of the respondent number 3. The respondent number 3 may respond to the application for condonation of delay filed by the petitioner, if so advised, within the next date fix. This matter after 2 weeks.
Item number 3.
In this matter, Lordship, in the last order, the case diary was called, Lordship. I have received the case diary, Lordship, and I have flagged the relevant documents. Lordship may peruse the case diary and
what does it say? More particularly, what is there? Is there the medical report? Is there?
Medical report is there.
What's the extent of injury?
Some injury, one. Fracture.
You have a copy with you?
Copy, I do a copy of CD, I do case diary, I flag it, Lordship, with medical report.
Then can you assist the court?
Lordship, I'll just give the page, Lordship, take out the page. Medical report.
You should have a copy with you.
This is the medical report.
Show it to Mr. Thapa.
Fracture and displacement of the knee. That is grievous.
There seems to be one of the injuries received seems to be a fracture, my lord. Only thing is,
so that would fall under.
It would fall under the my lord, the 320, the definition of 326. The only thing, my lord, here I'm a little handicapped today, my lord. Can we have this lordship some other day? Given the fact that Mr. Paul is not there and he's leading us in this case, my lord. The other aspect, my lord, of course, as it can be seen from the order, my lord. Even if apparently, admittedly, the injury was sustained when a brawl took place between the two parties, and it seems to have been taken place in the heat of the moment. Now, Your Lordship, given the fact that the accused person had been appearing before the IO, and had been cooperating, of course, it's the version of the IO that they are not saying what he wants to listen or hear, But in such circumstances, when the accused persons are readily cooperating, going before the IO concerned and giving all the material information, whatever is required, and also given the nature of offence that is charged against me, whether the custodial interrogation is at all required. In my humble submission, the custodial interrogation is not required because everything is based on records. There's nothing which is required to be extracted from me. So, my first prayer, at least, my lord, for today would be to have it some other day, my lord, given the constraint that I'm faced with today, my lord. Otherwise, my lord, like I said, if your lordship is inclined to still pass an order in the absence of the senior counsel, my lord, then my humble submission would be the...
If you are competent enough to...
Correct, my lord. I bow down, my lord. The only thing is, my lord, I have a very limited
If you have been
instruction.
duly instructed to appear, then of course.
My lord, first instruction that I received today is to, my lord, beseech your lordship to have it on Friday. Given that he has injured his leg, my lord, and he cannot stand, Mr. Paul cannot stand.
Oh,
He has injured his leg, my lord. He cannot stand for a long and he's limping.
okay.
So on the first, in the first hand, my lord, there was an instruction to me, my lord, to beseech your lordship to have it fixed on Friday, my lord, or else on Thursday, my lord.
Thursday, fine.
Thursday is a holiday.
So you and me can come on Thursday.
Thursday is holiday, lordship. Thursday is a holiday. It can be, since your lordship is already has perused the
We'll
CD.
have it on Monday then.
We can have it on Monday.
Yes, Monday.
Since that is a copy of the.
Yes, lordship.
Yes.
You don't have a personal copy with you?
I'll xerox it. I'll make one copy for
Yes, xerox it and give it the,
Yes,
give it to
good
the
master. Yes.
on pre-made by the learned counsel for the petitioner seeking accommodation in this matter on the ground that the learned senior counsel Mr. K. Paul is indisposed. The matter is adjourned. It may, however, be mentioned that Mr. H. Karmi, learned additional PP, has submitted that the copy of the case diary is produced today, and the same is kept on record.
There was an interim, my lord, since
Interim.
till
In the
the
meantime,
time.
the interim order pass
Continue.
will continue till the next date fix.
Highly obliged.
This is matter to
Highly
one.
obliged.
This is matter on Monday, fix now Monday. Monday,
Monday
6.
That's
So same order.
same order, my lord. Item 5 also. Deeply obliged.
Item number 7.
Lordship, I appear for respondent number 4. Hey, my lord, I had a small suggestion, Lordship. What has happened, my lord, is that initially an affidavit was filed by the previous counsel on behalf of respondent 4. That affidavit, my lord, admittedly had some there were some defects, Lordship. Thereafter, my lord, after
Typographical or
typographical and some other name with the names and so on so. So in fact, my lord, an order was passed on 9th of March, allowing me to file a subsequent affidavit. Now I have filed a subsequent affidavit without changing much of the original affidavit. In reply to that affidavit, my lord, the learned counsel for the petitioner, they have filed a rejoinder affidavit saying that my subsequent affidavit should be essentially discarded and the original affidavit should be taken into consideration. In such a situation, my lord, I fairly submit that the affidavit which was filed earlier would not be, my lord, sufficient for me to be in a position to establish my defense. This is an knockmanship dispute, my lord. So if I may humbly pray, without taking any further time, my lord, I'll file a fresh affidavit. I'll withdraw both the affidavits. I'll file a fresh affidavit, my lord. Because otherwise, if lordship sees there are 3 affidavits and 2 rejoinders, and none of them are actually on the material facts of the case, my lord. Unfortunately, I admit that there has been a mistake earlier, my lord, but in the interest of justice, lordship,
pleadings can
I
be
strongly
pleadings,
object to the submission advanced by the learned counsel for the respondent number 4, your lordship. This matter is part heard. The matter was first heard on the month of March. It was only after the petitioners made a reference to the affidavit in opposition. They woke up from the slumber. Now, your lordship, the matter pertains to 2018, and all along they have not been objecting to it. The briefer is all along in their hands. So I strongly object to the submission advanced by the learned counsel for the respondent number 4.
So what do we do?
lordship, in the interest of justice, I would pray that
substitute
it would be
justice,
it will help him as well as in this honorable court also to effectively adjudicate that.
Mr. Sangwa, you should know that the endeavor of the court as well as of the parties is to ensure that justice is done. It is not that we take advantage of technicalities, flaws in the technicalities or otherwise, the court should be apprised of all the material facts. Of course, the law will follow. But on the other hand, you also have a point, in as much as then the principle of laches will.
I understand, Lordship. I fairly submit that there has been some
rest
lapse,
upon the,
but in the interest of justice, my lord, it is required for me to file a proper affidavit.
Reference is already made, Your Lordship.
What,
Lordship, what happened was, Your Lordship, on the matter was heard on 9th of March from the petitioners, Your Lordship. Thereafter, reference was made to the counter affidavit filed by the respondent number 4. It is only thereafter they started realizing. A prayer was made before this honorable court by the counsel for the respondent number 4 that there is a typographical error in with regard to the name of the deponent. Now, this honorable court has granted permission to correct the typographical error regarding the name of the actual name of the deponent. Now, what they did was that they have corrected the actual name of the deponent by way of an additional affidavit. But what they did was also they have actually amended the plain, and a rejoinder to that effect has been filed with the lip of this court. Now, after all this, now they are coming that there is a mistake here and there, and they want to withdraw. This is something which, Lordship, I strongly object.
Why I submit, my lord, because all the affirmants in our affidavit as well as their rejoinder are only on technicalities. That is why there are no material facts, Lordship, on my affidavit as well as their rejoinder, which is why I may be allowed to file a proper affidavit, Lordship. In fact, of the order of 9th March, some leave was granted to me, my lord, to correct the name of the deponent as well as certain parts of the affidavit.
You have done it, like you have submitted.
Lordship.
The petitioner has filed a rejoinder to it.
Lordship. And in his rejoinder, he says that my subsequent affidavit should not be.
Whatever the case may be, that is a matter of argument.
Lordship.
It's up to the court whether to accept it or not. But if you see, you yourself have been found to be at fault.
These are inadvertent mistakes with typing errors and probably some
that
copy paste.
that can be overlooked.
Lordship, copy paste errors.
Even at the time of passing of the order or the judgment, if certain things are found to be incorrect, the court would sumoto correct it.
Lordship.
Perhaps with regard to dates or names, all those things. But that recourse have been taken by you. Now again at this point of time, Mr. Sama is correct.
Lordship, if my subsequent affidavit is taken on board, then we have to.
No, that of course. You can rely on your subsequent affidavit for all it's up to you. And the court will decide on whether to accept it or not. We'll go by that. At this point of time, Mr. Dev, I don't.
Otherwise, only for the convenience of
turning back the clock only, and especially when the matter is of 2018.
I understand.
Had it been 1 or 2 years, perhaps.
Not true. That.
So now, petition has been heard in this matter.
Yes, Your Lordship, but it was on the month of March.
Oh.
So perhaps, Your Lord, I may need to refresh Your Lordship's memory.
Yes, you have to refresh. So we'll continue, Mr. Dev.
Yes, Your Lordship, please, Your Lordship.
No, it's not a second. It's for you.
No, actually, I'm ready, Your Lordship.
This is your case.
I'm ready, Your
You
Lordship.
can have it after 2 weeks, my lord. I'll also prepare since
Why 2 weeks?
1 week, Lordship. We'll finish it, Lordship.
The matter can be taken up today, Your Lordship. And he has appeared in many number of dates. So it will be in his memory, Your Lordship.
Well, I'm playing for 2 weeks, my lord, so that I can just communicate that this issue, like now the picture is clear, we'll go for the hearing and we'll finish the hearing.
His submissions may be recorded.
He was the Nokma, he doesn't have any urgency, Lordship.
Mr. S. Dev, Learned Counsel for the respondent number 4, has submitted that the respondent had filed an affidavit, counter affidavit in this case in response to the petition filed by the petitioner. However, due to some defects in the said affidavit, a counter affidavit, prayer is made for this court to file a subsequent. Is it additional affidavit or did we call it affidavit? The subsequent one.
There are two affidavits, Your Lordship. Originally, the counter affidavit they filed in reply to writ petition, thereafter a typographical error.
Yes.
That is subsequent affidavit.
Supplementary additional affidavit.
Additional affidavit. Kurung to ko, the last line. To file an additional affidavit to correct such error. The same was accordingly filed, and in response thereto, the petitioner has filed a rejoinder. Now, at this point of time, the learned counsel or the respondent 4 has submitted that he is under instruction to make a prayer before this court to withdraw the counter affidavits as well as the additional affidavit filed before this court and to file a fresh counter affidavit. The prayer made was strongly objected to by the petitioner, who has submitted that this case is at the stage of hearing when the matter is already part heard, and to allow the respondent 4 to file their pleadings at this stage would not be in the interest of justice as far as the petitioner is concerned. Also considering the fact that this matter is of the year 2018. This court, on consideration of the submission made, would agree with the legal counsel for the petitioner and would opine that at this point of time the respondent by their own the respondent 4 by his or her
The deponent is a lady.
own action has not made out a case for filing of fresh affidavit. Though at this juncture the learned counsel for the respondent 4 has submitted that he may be allowed to rely on the subsequent affidavit, counter affidavit filed. Accordingly, in such circumstances, the matter is left to the parties to argue their case on merits and to rely on the pleadings placed before this court, and to rely on the pleadings available from the records. Accordingly, the matter shall therefore proceed for further hearing. On prayer made, this is matter up to 2 weeks.
Item number 13.
My lord, this is a part-heard matter regarding the 2-3 occasions the matter has been heard, and the learned AG also concluded his argument, so we will try to shorten short reply, my lord. As far as I recollected, my lord, I will not take the documents in detail, but 6 essential points argued by learned AG.
Yes.
Number 1 is petitioners suffer from delay, delay in laches. Number 2, my lord.
Are you appearing in both the cases, Mr.?
My lord, I'm appearing for number 1, and other is appeared by my friend.
Okay.
First issue raised by learned AG is that there is a delay, so therefore REIT suffer from delay in laches. Number 2, there is a disputed question of facts, therefore REIT is not maintainable. Number 3, the period for granting the disaster,
Yes.
in this case, was beyond the period prescribed by the government. Number 4, my lord, he contended that there is a breach of contract. Is a breach of contract, therefore contractual breach cannot be enforced by this honorable court. Number 5 is, my lord, there is a violation of norms. So these norms cannot be enforced before this honorable court. Number 7, lastly, the writ petitioner was very much aware of the contract. Before contract was awarded, petitioner was part and parcel of the moving of the file, very much aware of the process. Therefore, there was instigation, so it doesn't deserve any relief. My lord, with regard to first point, delay in laches, I will take, my lord, few annexures and say that there is no delay. Now, the disaster took place on, my lord, 2014, November 2014. Now, my lord, we see the writ petition, my writ petition.
Or is it September?
September,
not November, September.
September.
22nd.
September 21st, 22nd September 2014. And it was implemented by early part of 2015. Now, Lordship, kindly see, to reply to the learned AG submission, Lordship, kindly see my annexure in the first writ petition. Page number 14 of the writ petition.
Yes, page
number 14, madam.
Annexure 1.
Annexure 1. Now, this was the meeting held by the committee and fixed the rate. This was taken place on 5th November 2014. Now, pursuant thereto, my lord, the next page, on the same date, my lord, this was the letter issued by the Deputy Commissioner.
This is 5th December, isn't it?
Yes, 5th December. 5th December.
Yes.
In the next page, 15. This is, my lord, dated 5th December, same date.
Yes.
And this letter was issued by the Deputy Commissioner to the Veterinary Department. And now the learned AG has pointed out, referring to in the affidavit, it says, copy of your letter dated, number dated 14/11/2014. Here in his affidavit, he says that this is the letter of the writ petitioner. This is absolutely wrong. This is the letter of the veterinary officer. So DC is referring to the veterinary officer letter, not my letter. So the one limb of argument was by learned AG that I was part of the process of file moving before contract awarded is absolutely without any basis as per record. Now this was issued and the work order was issued on, my lord, the next page, page number 16. I'll move quickly to answer the delay matter. 8 December was the work order.
Yes.
And the next page 17, the 21st January 2015 is the second work order.
Yes.
So it was implemented immediately within the first part of 2015. Now thereafter what happened, before I take to other annexure, Lordship kindly come to the affidavit filed by the veterinary officer my lord.
Yes. That is in the affidavit.
That is, my lord, veterinary officer, Lordship kindly see, affidavit filed by respondent number 5, veterinary officer. My lord. It was filed on, my lord, 20 March 2023, this year itself. And annexure, Lordship kindly see, page number, what is 27.
Yes.
Now, this is the internal communication between the veterinary officer and the deputy commissioner.
Page
number 27, annexure R2. Where it says that there was no game was established and distributed, and subsequently there was a letter that this was a wrong information. Now this was on 16 October 2015, after implementation.
October 2015.
15, my lord.
Yes.
And thereafter, the next page, page number 28, 3rd February 2016.
Yes.
This is the letter written by the Deputy Secretary Disaster to the Deputy Commissioner.
Yes.
That after receiving letters, relevant papers from the Deputy Commissioner for sanctioning, now the government has communicated that, may I just read, my lord. So I am directed to refer to your letter cited above and to say that item number 6.2 of the State Disaster Response Fund norms states that provision for the concentrated, including water supply and medicine in cattle camps. Since feed were supplied outside the cattle camps, they said supplied outside the camps, the proposal of sanction of fund out of such for payment appeal is not eligible under the items and norms of the State Disaster Response Fund. In view of the above, bills and all other concerned papers are returned herewith. Now, the only sole ground taken by the government is that the feeding taken place outside the camp. There was no camp, so sanction cannot be made. So this communication was made on 3rd February 2016, my lord. And Lordship may kindly see 2016, and the file continued to move, Lordship, and my lord, we come to page number 30 in the same affidavit. Now, in the month of April, this letter was written by the veterinary officer to the Deputy Commissioner.
Yes.
And it says the earlier clarification regarding setting up of relief camps was a mistake and it is highly regretted. So there was a miscommunication. So there was a camp. So the fitting took place within the camp. And now the enclosure, Lordship, can you see area of distribution, beneficiary list, village abstract, Chalan bill, utilization certificate, photo, and list of relief camps. These are the particulars furnished to the Deputy Commissioner. And the next page,
where are these?
But page number 30 of the affidavit.
Where are these enclosures?
In enclosures, my lord, it must be with the record now, since they have produced the record before this record. It must be there, my lord.
Okay, the record is here.
Yeah, record is.
Yes.
My friend is supposed to produce today now, my lord. And the next page, page number 31, 21st October, my lord, another letter was forwarded. And in the last part, my lord, relief camps duly approved by the Deputy Commissioner, North Karo Hills, Rusupil Para is also attached herewith. Relief camps certificates. So all the details were furnished. And this was written by the, my lord, by the veterinary officer. This took place in October 2016. Now, how my lord, did delay take place, my lord? The file is moving, the issue is moving, process is going on. There is no delay. The clock of delay never started ticking, even now. And thereafter, what happened? Lordship, may kindly come to my lord. page number 29 again of the same affidavit. This letter was written to veterinary officer. Another veterinary officer, Dr. M.K. Sangma, earlier was City Sangma,
Yes.
the one who issued utilization certificates in other letters. Now this a new veterinary doctor officer who assumed the charge, also given the same a letter to the Deputy Commissioner. My Lord, in closer, I just point out corrected challan bills, corrected quantity of feed distribution list, photos and clarifications. These are all must be with in the record now. This was on 28 September 2018. And now, my Lord, come back to my writ petition page number, my Lord, page number 19 of my writ petition.
19.
19, my Lord. Page 19, my Lord, Annexure 6. Now, after receiving all this clarification from the veterinary officer, the Deputy Commissioner has furnished the details to the government.
Yes.
To the government. And this letter was given on 4th October 2018.
Yes.
Well, and the next page, page number 20. Hello. Another letter was put forward, page number 20.
Yes.
On 19 November 2019. So the process was on. Now by this letter, the entire issue is now based upon depend on the government to take a final decision. Now all the details are given. Now government was supposed to take a final decision in 2019. They did not take any action, any decisions. After perusing the entire records, if they have a doubt, they can pass a final order. They can go as an inquiry if required, but they did not do. They did not do, despite all the materials supplied. Now thereafter, my Lord, page number 21, petitioner has filed a representation, my Lord.
Yes.
That is on 18 February 2020. That is within 3 months of that Deputy Commissioner letter, my Lord, urging the competent authority, that is the veterinary officer, to look into the matter for sanctioning. And nothing was happened.
Yes.
And therefore, 2020 itself, madam,
Yes.
we have filed the writ petition, first writ petition.
2020.
20, page number 22, madam. The order is there. And this Honorable Court directed the writ petitioner to place a fresh representation put up before the government, so the government can take a final decision, veterinary officer. And page number 23, my Lord, promptly the writ petitioner put up the fresh representation.
Yes. Yes.
And the last communication, my Lord, is the 4th January 2021. This is the letter disposing my representation. Only last part may I just draw Lordship attention.
Yes.
I will make the payment, it says, I will make the payment as and when the fund is made available by the concerned Department of Revenue and Disaster Management. Therefore, for kind information, and such. So the veterinary officer, the implementing department, asked me to wait for some time. And nothing happened. Therefore, within 9 months of this, from this letter, we have filed this present writ petition on 4th October 2021. But there is no delay. My case would be different, my Lord, with due respect. Each submission would be found favor in the eye of law. If the matter ends up in 2015 and nothing moved, my Lord, there is no internal communications, matter end up there, then suddenly I rose up in 2020 file a writ petition or representation, come to court and file a second representation, and the government said that there is a delay, we cannot consider the matter. My case is squarely hit by the principle of delay in largesse. But here, admittedly, my lord, the file process is going on. So how the citizen can be blamed for delay? When citizen approach, the government asks the citizen to wait for some time. Process is on. If the process is on, my lord, the issue survive. There is no question of delay. So the first round of first theme of argument advanced by learned AG that there is delay is absolutely, my lord, incorrect. Secondly, my lord, we have argued there is a disputed question of facts. Now, who raised that issue? Admittedly, my lord, under the state plan, framed under disaster management, it is the veterinary department, along with the deputy commissioner, implementing the project, the relief project. Now the government, who is the policy maker, a sanctioning authority, without any materials, raise a note, in affidavit, say there is disputed question of facts. Government must demonstrate there is a dispute. The only dispute they raise in their document is that you do not supply in the cattle camp. That is the only one. Now the affidavit filed by the competent authority, that is the, my lord, veterinary officer. My lord, may I just take, in this affidavit, my lord, veterinary officer, in this affidavit, there are, my lord,
affidavit of respondent 5?
Yes, number 5, my lord. My lord, there are, we can say 32 paragraphs are there in this affidavit. And now, out of this, my lord, para 5 to, my lord, 17, it contains the law point that there is a disputed question of facts. Writ is not maintainable. Contractual obligation cannot be enforced before this honorable court. It is settled law, citing the law, but not answering on the merits. Now, para 18 to 31 of this very affidavit, the veterinary officer, my lord, he has completely admitted that yes, disaster took place, committee set, sanction was made as per the fixing of the rates. It was carried out. There was internal communication earlier, some communication mistake was there. We corrected, we furnished the bills, the challans, the photos, list of beneficiaries, everything. All admitted. And now only all after admission, I'll just point out the last para, my lord. Para 32, lordship kindly see. Para 18 to 31, he admitted everything. That there is no dispute. But para 32, it says that it is submitted that the claim is therefore not tenable in law and liable to be rejected on this count alone. My lord, I never come across, my lord, when the government admitted in its affidavit, fact of the case. Really surprising to take this plea that petitioner do not deserve relief. But
these are just, you see.
My lord, in fact, therefore, my lord, it is a prerogative of the government to file affidavit as much as the citizen. But my lord, when the fact is admitted, this very statement is contrary to the facts stated earlier paragraph, para 18 to 32.
Yes.
There are only one para, para 27, lordship can you see. The only issue he said, para 27.
Yes.
It says that in the respect of submission of the deponent herein that the above decision was taken bona fidely. However, in view of the revenue disaster management, is that the arrangement of not having cattle in the relief camp is contrary to the requirement of such and such. of the Sunset Fund. Provisions of further fit concentration, including supply in medicine in gather camps. This, in essence, is the point of difference only. The difference between the government, one side, and the other side, collector and the veterinary department, is that fitting did not take place in the camp, relying on the first communication. Now, whereas after verifying in their records, they said, oh, sorry, there was a miscommunication. Therefore, fitting took place within the camp. So there is no dispute. Therefore, once my lord, the officer who implement the agency under the Act as implement agency admitted the fact, the higher authority who never involved in the ground reality cannot dispute without any materials. And there is no materials annexed by the affidavit filed by the my lord. No, there's who is that? Mr. Ripnal Lingto, Commissioner and Secretary who filed the affidavit. There is no material he demonstrated that there is a dispute question of facts. No, nothing, my lord. The only strong averment he has taken is, my lord, para 8 of that petition, my lord. Para 8 of that affidavit, lordship kindly see.
Yes.
Para 8, my lord.
Yes.
He only said, my lord, in the, might just take from the 1, 2, 3, 8 lines from the bottom, may I read, my lord. It is a matter of record that the empanelment of supplier firm.
You are reading para 8 of?
Para 8 of the affidavit filed by the state government. 1, 2, 3, and 4.
Yes.
Filed by Mr. Ripner, Commissioner. Para 8. It may just start from 8 lines from the bottom, my lord. It is a matter of record that the empanelment of supplier firm for supply of feed to government have to be carried out in a fair and transparent manner as per the Government of Meghalaya memorandum. It is clearly stated that any purchase above 50,000 has to be done in fair and transparent manner. Even assuming without admitting that the order was placed by Deputy Commissioner Revenue in violation of the above government order, the same is illegal and without any authority, and it cannot bind the state government. This is one of the stronghold of ground taken by him in his debate.
Yes.
Now he says, if the matter involves above 50,000, there should be a NIT. That's what he meant. There should be a NIT, competition would be there.
Yes.
But nowhere Disaster Management Act contemplates NIT. If that is the case, that will defeat to face the natural calamities, my lord. NIT is flooded, tenderer will contest the tender, my lord. How the state will face the natural calamities? Therefore, it is a separate act, my lord.
See, natural calamity, if we can understand in layman's term, is when it happened, and immediate action is to be taken.
Right.
So, because of the emergency situation, so perhaps NIT and other things may not be required.
Correct.
But what happened is, the disaster took place in September.
Yes.
But this process took place in October.
70, yes.
Or
70 days, 76 days, I count.
Yeah.
76 days.
Then the question of emergency will not arise.
No, my lord. That is one of the limb he has advanced. I will come to that one. Now, before I come, I'll complete my reply to that disputed question of fact. There is no disputed question of facts. Okay. The one who enforced Deputy Commissioner and Veterinary, they have admitted that yes, they have done the work. They have done the work. And who implement? It is not the Commissioner and Secretary Revenue Disaster. It is the veterinary matter. Last time I have submitted the management plan, lordship can you see in the record. And this plan is framed under the Disaster Management Act, madam.
Yes.
Lordship, we kind of straight away go to page number.
Just move.
My lord, yes. Page number 87. page is reflected.
I'm sorry, my lord. Is it part of the record? Is it part of the record?
It's already there, submitted in the when I argued.
Now?
It was already there, madam.
This.
Yes. Now, page number 87.
You have you.
It must be, madam. On the first day, we have submitted to my friend also.
No, because I don't see.
I think your colleague must have it.
Yes.
We have, yes.
No, not because I'm.
This is a public document in any case, Mr.
Right. They are the
Yes,
author.
so then whatever is being submitted, what is happening, my lord, in rejoinder it is being submitted. How will I be? It should have been argued in the petition itself.
We have, my lord, we have argued that point. We have, with due respect, we have argued that point. No, no, this is uncalled for.
So then I will get a. I will meet the argument.
My friend is having the copy. If I do not advance an argument, I would not supply. I supplied the copy and I advanced the argument. Now let me conclude. Otherwise, this would be inconclusive.
Only thing I'm praying, if there is a new argument which has not been advanced at the British stage, I should be given opportunity to make. That's all I am asking.
We have advanced already. I'm not bringing a new argument today. It was already advanced already, my lord.
New material.
No, it is not new material. With due respect to learned AG, your friend is having a copy that was already advanced. So I just want to point out only one page only. Page number, my lord, 87 only.
Page?
87. Chapter 14 is on the top.
Yes.
It says, livestock management during emergencies and disaster. Now it says that Department of Animal Husbandry and Veterinary, Government of Meghalaya is entrusted with the responsibility of all aspects of livestock and poultry development as well as preparation of disaster management plan for livestock. I will not read down the entire. So the task was given to the veterinary department with regard to poultry and the cattle and livestock. They are the implementing authority. And the implementing authority say that yes, we have carried out the project. Therefore, it is not the commissioner who can raise disputes. If these people raise a dispute question of fact, that they can raise. They are the authority. I was on the ground. You never come and implement the project. You never give me the detail. No challenge, no area identification, no beneficiaries. They can do that. But the one who are in the ground said, yes, you have done it. The one who sits in the secretary without any record, how can they raise dispute question of facts? My lord. Therefore, the argument advanced by learned AG earlier, my lord, I got surprised. Now, government is speaking two voices here. Commissioner, secretary say that no, there is disputed question of facts. Project is not implemented in accordance with law. Now, the veterinary department says that yes, it is implemented. One single government speaking two voices. I'll place the decision, my lord. So there is no disputed question of fact. Now, other points, my lord, important points learned AG has raised is that, my lord, the period, my lord. Disaster took place on 21st September 2014, and meeting set in December. Supply took place in January, and implementation took place in 2015. So after a much gap, that is, my lord. Lordship, we kindly come to page. They have a next page number 22 of the affidavit filed by a veterinary officer.
This revised list of items.
My lord, this is the letter, in fact. This is the letter issued by the government from time to time. Is a letter.
Oh, it's a letter?
Is a letter. And this is, my lord, 21st June 2015. Now, straight away we will come.
2015 or 13?
Learned AG also refer. Lordship, we kindly come to page number 24, item number 6, animal husbandry.
Maybe.
Page number 24. Point number 6.
Yes, 6.
Yes. Now, page point 6.2, Roman number 2, and Roman number 2 is available in page number 25. My Lord, a provision of further fit concentrate, including water supply medicines in cattle camps. Now the department is harping on this. Commissioner Secretary Disaster is harping on this, that it should be only in the camp. This is the guidance, my Lord. Whereas the Act, Disaster Management Act, my Lord, it never emphasized that the relief can be only supplied within the camp. It is the instructions only. This letter is the instructions for the purpose of convenience, easy administration of disaster management. My Lord. It is not that it is not taken place within the relief. Relief cannot be extended. It is not. As far as possible, as much as possible, relief should be done within the camp for easy management convenience, for easy administration. If it is outside also, my Lord, disaster has to face by the state government. My Lord. Now, therefore, they are hinting on this, my Lord, that you have written a letter that there was no relief camp. Therefore, you are not entitled. Those subsequent clarification is there. So, despite of clarification later on came forward, they are referring to this. Now, my Lord, and the period they have referred, period is mentioned, my Lord. Period is a period for providing relief will be as per assessment of the State Executive Committee and central team in case of a national disaster. The default period for assistance will be up to 30 days, which may be extended to up to 60 days in the first instance, and in the case of severe drop, up to 90 days. These are the guidelines, my Lord. These are the guidelines, my Lord. Relief is required to be attended immediately, correct. But if the relief require, my Lord, prolonged attention, my Lord, prolonged attention, the disaster management do not prohibit that one. It did not say that after one month, 2 months, no matter disaster continue, government cannot go on helping to rescue the disaster, a person who faced a disaster. It is not. It is mere guidelines. It is a mere letter. And therefore, this is not at all taken away the object, my Lord, enshrined in the Disaster Management Act. It's only a guidelines. It's a letter, my Lord. They issued from time to time.
No, but it could be guidelines. But you see, it is based on the practicality of the situation.
Yes, exactly. Because normally, Lordship is right. Disaster cannot be delayed. Disaster has to be faced immediately. Immediately. That is the object of this letter. But if the situation arises that if disaster is prolonged, disaster has to be met. It has to be attended by the government. And now the Roman number 3, Lordship kindly see, transport of fodder to cattle outside cattle camps. This is part of the relief exercise, madam. And how they emphasize that it should be only in the relief camp.
Okay.
So this is another clarification I want to make. And another third point, the learned AG say that there is a breach of contract. There is no breach of contract. The sanctioning authority on the ground sanctioned or issued the work order.
What do you mean to?
I did not, my lord. I don't know.
What do you mean to say? If you are emphasizing on this 3, transport of fodder to cattle outside cattle camps. So you mean that this will be applicable in your case?
My lord, for transfer, my lord, the supplier has to procure the materials in some other place, and transportation required, transportation costs involved. These are all part of the relief exercise, my lord. Relief exercise. So, my lord, how the relief exercise can be only confined to one camp.
Yes.
It requires, my lord, for to construct, my lord, this massive building of this Honorable High Court, my lord. It requires a huge transportation cost involved. It is part of the contract, part of the cost of the constructions.
No, that is
not natural. Therefore, when the AG argue, I do not interfere.
Mr. You'll get your. I will allow.
I never interfere.
I will allow you. Fine. I will allow you to respond. Just.
Yes, my lord, the only thing he's saying, I argued this.
Just hold your.
I did not argue what my friend is arguing.
Hold your horses.
Yes. What I'm doing is I'm not putting words to the mouth of the learned AG. Learned AG argued that relief camp is the place for meeting relief requirements. I say that it is not only a relief camp, even outside also it can be, and transportation is one of the segment to meet the relief exercise. That's my argument. I'm not forcing him that he has advanced that argument to nail me down. Not. It's a relief exercise. This is my limited reply. Now another point is, my lord, learned AG said there is a breach of contract when we issue the affidavit, so contractual obligation cannot be enforced. My lord, there is no contractual obligation, the conditions violated by anyone. Sanction was made, work order issued, supplied already, utilization certificate supplied, authorities collected all the relief challenge, particulars, photos, beneficiaries submitted to higher authorities. Higher authorities supposed to take a decision. There's no the contractual breach of contractual condition, my lord. And the fifth part, he said, my lord, the norms. He was vehemently emphasizing about the norms, and the norms which we read out. That one, that 6.6 Roman 2 relief camp, and another norms initial affidavit. He says that 50 any purchase amounting beyond 50,000. It requires open and transparent exercise. This is not required. This is not required in the relief and disaster management. Therefore, I'll come to the law point. Now, the one law point is, my lord, the law of filing affidavit, the writ proceedings, my lord. It is unlike the civil. Civil, we file a simple plain because the party will have the ample opportunity to produce the documents, to file the documents, frame the issues, adduce the evidences, cross-examination. Writ is completely different. Therefore, filing a writ, my lord, filing a writ petition need to accompany it with the material facts, so also the state affidavit also. Now, the state affidavit, there is a judgment. Once the state officer file an affidavit, state officer file affidavit on the basis of what? Not his own learning, but on the basis of the record. Now, there's one decision, may I just cite? I have cited also, my lord, I'll just... I will not cite other judgment which we have cited already. Just kindly bear with me. I'm so sorry, my lord. Yes, my lord. 2004, volume 10, SCC. Page number, my lord, 734. 734.
Para?
Relevant para will be para 15, my lord. Para 15.
Yes.
My lord, it says, the learned counsel for the respondent tried to explain this clear admission on the part of the state government by saying that affidavit was only by an officer of the government and did not necessarily represent the view of the government. In our opinion, this argument is highly technical and least responsible to carry any credence. Firstly, the officer was implicated in the contempt petition as a respondent because he was holding the key post at the relevant time. The officer filed the affidavit on the basis of the record of the government, which fact has been so stated in the affidavit itself at various places. Secondly, the state government has reiterated the same view in the counter affidavit filed in response to the SLP in this court. We are surprised that in spite of these facts, such a contention is advanced by a senior counsel appearing on behalf of the respondents. So my lord, the law laid down in this case is once the officer filed an affidavit on the basis of the records, government cannot, my lord, dispute that one. Government cannot blow hot and cold. Hot and cold, my lord. Therefore, the affidavit filed by the, my lord, commissioner and secretary is one here, and affidavit filed by the veterinary director is another, my lord. And the authority is the director. Government cannot blow hot and cold. Hot and cold. Therefore, the affidavit filed by the government, by the veterinary officer, who is the implementing agency, controlling officer on the ground, cannot be ignored. It carry better weight than the other affidavit filed by commissioner without any records. Now, another decision, my lord, may take that the citation. These are criminal citations. Well, it is a Supreme Court decision. I compiled it with my friend. My lord, we come to my lord, page number para 52 and 53 only. I flag it, my lord.
There is no, it's not, this is not yet reported.
Well, this would be a reported judgment, in fact,
I think it should be even
2022.
It should be SEC online, if not, but 22 should come in SEC.
My lord.
It would be better if you give the proper citations there.
SEC, my lord, maybe we download, but
Yeah,
my lord,
yeah. Where even a civil appeal number is also not there.
but it is, we will supply, my lord, the proper downloaded SEC, my lord. But we will with lordship permission. Para 52 and 53. Well.
Para?
Well, para 52 and 53, may I read, with lordship permission. The law is succinctly held by this, by the Honorable Supreme Court. The flag we make. It says, we are of the considered view that it does not go well for the Union of India to speak in two contradictory voices. The two departments of the Union of India cannot be permitted to take stands which are diametrically opposite. We may again freely refer to the following observations made by a three-judges bench of this court in the case of Lead Electric and Engineering Limited versus State of Himachal Pradesh. The state government cannot speak in two voices. Once the cabinet takes a policy decision to extend its 2004 industry policy in the matter of GST concession to the eligible units beyond sunset 2009 up to 2013, and the notification date sunset 2009, accordingly having been issued by the department concerned with Department of Industries, thereafter, the Excise and Taxation Department cannot take a different stand. What is given by the right hand cannot be taken by the left hand. The government shall speak only in one voice. It has only one policy. The departments are to implement the government policy and not their own policy. We therefore impress upon the Union Army to evolve a mechanism to ensure that whenever such a conflicting stands are taken by different departments, they should be resolved at the governmental level itself. Here, the two contradictory affidavit has been filed. Commissioners say that there is disputed commission of fact. We never performed the contract. No disaster exercise was done, and the veterinary says it is done. So this is absolutely legal. In the writ proceedings, my lord, the government that has support of facts, the record will prevail. And therefore the government made by the veterinary officer has the support of the records. Another point, my lord, may I just point. Now, learned AG has given numerous citations, my lord. It has my lord, with due respect, it has no application to my case. I do not need to refer to all the decisions referred by him. I have received a copy from him. The land ledgers also, he has referred few cases. Contractual nature, that writ has no jurisdiction, my lord. I don't need to repeat, my lord. So, with due respect, in short, the citation relied by learned AG is, my lord, not suitably applicable to my case. The last one, but not the least, now the surprising is, my lord, the state has completely denied my contract, my service, my case and my friend's case. No contract. If that is the case, the same disaster, they have sanctioned more than 1 crore recently. The same disaster that took place under the sun, the same calamities, the same areas, the same department, the same sanctioning authority, the same government. That was brought on record through affidavit. Now, therefore, if my contract is incorrect,
so the principle of parity would,
my lord, exactly, my lord, how the government can choose and go for pick and choose. That you are not the blue-eye boy. Another one is the apple of the eyes. So I give favor, I give sanction to you. 10 years ago, 15 years ago, I'll give you now. In my case, no, there is a 7 years delay. You cannot come and knock the door of the court. But this is, my lord, where the citizen will go. Imagine, my lord, assuming that lordship do not persuade my argument, unable to take the confidence of my lord, and already is dismissed on the technical plea raised by learned AG. Will not get any relief. But a similarly situated person, my lord, who enforced the same contract, he enjoy. My lord, in the eyes of my lord, in the eyes of the writ court, this is revealed. This is revealed, my lord. In that event, my lord, the writ court, my lord, the writ court,
yes,
the procedural laws, lordship is well aware, procedural laws is the handmaid of justice. Procedural laws cannot be the obstacle to dispense justice, my lord. And here, my lord, we are invoking the equity jurisdictions. And this equity jurisdiction, my lordship, has enough power, my lord, to correct the mistake committed by the government. Now the ball is kicking between the veterinary DC and the government. And we are in the middle. And we're in the middle, 2 of us are victim, 1 of us lifted the trophy, and he is enjoying. And when we come here, my lord, before this honorable court, that is say we are wrong. We don't deserve to come before this honorable court. My lord, citizen has no more place to go. Therefore, we come before this honorable court. Therefore, my humble prayer is...
have you read the other parties are responded?
Subsequently, during the course of hearing, it was revealed. Therefore, we brought on the court. And the state is not denying. If the state deny,
whatever the case may be, whatever the case may be, that is also a process of natural justice.
Right.
That if aspersion or any contradictory remark has been made against anybody, it should be
no. If we seek relief against him, or if we ask the court, this court to deny relief to him, it is my paramount duty to implead him. But I'm just bringing on record that when we are litigating before this honorable court seeking justice, outside the court, my lord, government is doing favor to somebody blue-eye. We are pointing out, and government is not denying.
Yeah, that is also for the government to respond.
Right, and AG fairly enough, as usual, fairly enough, he has considered that yes, sanction was made. According to his personal view, this is not correct, but sanction was made. Government has done it. and the same government is not doing
Government
to
has
me.
proceeded. No, I have not considered anything.
Just a moment.
What is beef?
My lord, last time he said that yes, sanction was made. I considered according.
Sanction was no, never. Please,
Just
when did I say sanction was made?
Oh my lord, even
Because
the earlier
the only problem,
argument
the only
recollected.
problem is what is if we argue whatever, I have no difficulty with that. But it is that I am saying
Mr.
something
Kumar,
which I have not said.
please don't,
That
please,
is the time of taking.
Mr. Kumar, please don't get excited. You'll get your turn. Let Mr. Sagriso finish his.
I will definitely conclude, my lord. Normally, the law practice we learn from the learned senior, the seniors many a time. Writ petitioner address the honorable court. Respondent will address, and writ petitioner will have a short opportunity to give a reporter, rejoin the matter close. But now the learned AG wants to reopen again, then ultimately I will seek. That will be another exercise. That is not the time. So my argument is that let us respect the decorum and the procedure. I will conclude my argument, and if Lordship permits me, we will may be allowed to give a brief synopsis, bullet points of our argument. And my prayer is, it is a fit case, Lordship may intervene. And in case, alternatively, my prayer, after perusing the records, since record has been produced, perusing the records, if it requires for warranting inquiry, causing inquiry, we have no hesitations. I don't know my friend's side, but my side, I have no hesitation to face the inquiry. But let the inquiry be also done by impartial one, not the government department, impartial judicial officer or commission. Let them unearth the truth. If I'm guilty, flouting the government, I will face the law. If the government officer, my lord, I humbly request the learned AG not to interfere.
Sorry.
And if the government officer playing around, playing fraud with me, for instance, not admitting, they also need to face the music. They receive the service of the citizens, and they cannot play around and walk away. This is unfair, man. Unfair. So first prayer is, Lordship may consider my prayer, entertain the petition, direct the government to pay within a time frame. If not required, my lord, at this stage, direct for a fresh inquiry and give a report before this honorable court within a time frame 2-3 months and take a final decision. My lord, it's my humble plea. Highly appreciate.
Inquiry on what ground, on what basis?
My lord, my lord, the earlier learned AG also said that it is required inquiry. I don't have any hesitation.
If inquiry is to be conducted, that would be the initiative of the government, because the person concerned is their employee.
Exactly.
So,
therefore, inquiry cannot be conducted by the veterinary also. It cannot be conducted by the disaster management also, because among themselves, they are fighting. They are not in one. They are not in tune to each other. They are in conflict, my lord. Therefore, if Lordship desire, the suggestion, if situation arise, Lordship may direct even the district and session judge to conduct an inquiry and give a report. Everything will come out. Alternatively, otherwise, my humble submission, it is a fit case. It is a fit case. Government cannot discriminate to equally assimilate a situated person. Highly appreciated.
yes. More or less, your points have been covered by Mr. Sangha.
I just want to point out a few documents from my pleadings, more or less on the same issues. Dates are slightly. I will not repeat, my lord, whatever my learned senior has said.
Yes, ma'am. But again, I think your response should be on law points.
Not only on law points. I'm just trying to show, my lord. The first thing is on delay. Till up to the, my lord, the processing of the file and everything, where the communications were exchanged and it was later on clarified, they're all more or less the same, my lord. Lordship may only come to page 50 of my writ petition. Just on the point of delay, my lord, I'll just show one document. This is also similar to what was given to, my lord, the first petitioner at page 50, annexure 9, lordship. Lordship will kindly see the type copies at the next page at 51, my lord. So this is the letter, my lord, issued from the District Animal Husbandry Officer 1 Dr. C.D. Sangwa to the, my lord, petitioner on 26th October 2021.
Yes.
And in essence, my lord, this letter gives reference to my bills and says, with reference to the subject cited above, I have the honor to inform you that the office of the undersigned is yet to receive the payment of the bills mentioned above from the Disaster and Revenue Department till date. The payment will be made as and when the amount is made available from the concerned department. And a copy has also been given, my lord, to the Deputy Commissioner.
Yeah.
So on 26th October 2021, my lord, there is acknowledgement on part of the government that there is no dispute as to the non-payment, or it is a acknowledgement, my lord, that yes, your bill has been submitted, we are yet to receive the payment, we will make the payment once the fund is arrived at. No other reason as to the disputes which has now sought to be raised have been raised, my lord. And this is an acknowledgement of 26th October 2021. So if they acknowledge, my lord, that on 26th October 2021 that the fund will be paid, there is no question of delay, my lord. And even if it was a money suit, the date which is important is from the date of acknowledgement, my lord. So in any case, there is no delay, even if it was a money suit. And in the writ proceeding, my lord, in considering what my learned seniors already showed, the process that was ongoing throughout the interregnum, there is no delay, my lord. If we have filed the writ petition 2021 itself, claiming on the basis of their own letter, which says that we will make the payment as and when the fund is available, lordship. So on the delay, my lord, I humbly submit there is no delay. Now only on the questions of disputed facts, my lord, I would only like to show your lordship the affidavit filed by respondent number 3, my lord, which is again similar, my lord. The first 10 pages are transcripts of judgments. Lordship will kindly come to page 10 of the affidavit filed by respondent number 3. Page 10, my lord.
Yes, ma'am. Page 10.
Lordship, page
Para?
10. Oh, para 18 onwards, lordship. 17 onwards.
Yes.
Lordship, para 17 says that there was a flash flood in the month of September 2014. The floods caused large-scale destruction in the region and necessitated urgent relief and rehabilitation.
Just a
So and so.
Just one.
Page 10, my lord.
Page 10, para 17.
Lordship.
Yes.
There was and from paragraph 18, my lord.
Yes.
Accordingly, wide letter dated 24th November 2014. Lordship will kindly note the date. 24th November 2014, the District A&H Veterinary Officer North Garhwals initiated request for supply of animal and poultry on short notice. On short notice, my lord. After inquiry, my lord. So this inquiry would suggest the census and everything, the actual need for the relief. After inquiry, the District Disaster Management Committee, wide letter dated 27th 11/2014, identified the petitioner as one of the firm suppliers who was in a position to make available the necessary stockpile of feed on short notice. So this paragraph, my lord, suggests that there was an inquiry before the supply was made the committee itself has gone into the inquiry and initially found me as well as the other two to be in a position to supply on a short notice, my lord, and necessary stockpile, which necessary would mean, my lord, that we are not supplied anything which is not necessitated. It is the necessary stockpile which we have supplied. Lordship, kindly see paragraph 20. On 5th December 2014, the Deputy Commissioner of Revenue convened another meeting of the District Disaster Management Committee. These are the competent authority, my lord. The Commissioner and Secretary of Revenue Department has nothing to do here. For addressing the issue, the 3-member committee fixed the price at the rate of Rs 35 per kg, which is consistent with the rates prescribed in this regard as per the revised list of so and so. So, my lord, there is no difficulty with the rates.
Okay.
It is not the case that the rates are.
This is a prescribed rate.
Prescribed rate, my lord. The same list which they have also referred to with regard to that it has to be supplied in the camp.
But there, I think the list says 25.
No, that lordship will kindly see.
And 6.2.
I'll just come to that, my lord. 6.2, they have mentioned here only. Provision including water and medicine supply in cattle camp. I'll just come to that, my lord. Lordship may kindly come to.
He has inaugurated a number of the district court complexes, etc. Infrastructure, digital infrastructure. Meghalaya.
Yes, Mr.
Meghalaya. I'm sorry.
Mr. Kumar?
I'm sorry.
What is?
I'm sorry. I have to prepare the speech also, my lord. That's why I was.
Paragraph 22, my lord.
You have lost interest in the case, so.
I will conclude my argument in 2 minutes once my friend is.
So after this rate was fixed, inquiry was done, everything was done, my lord. Paragraph 22. In the above manner, the short notice supply order was issued after due approval of the DDMA. This would mean the, my lord, the competent authority under the Disaster Management Act. Paragraph 22. At page 12, my lord. So one line. This is all from the affidavit of the department, my lord, the government. Short notice supply order was issued to the petitioner herein after due approval of the DDMA. This would probably District Disaster Management Agency or Authority, lordship. Thereafter, my lord, that when the supplies were executed, admittedly supplies were executed, lordship, pursuant to placing of the supply order, the petitioner came to raise bills dated so and so and so and so. That by a letter dated 2nd March 2015, District Animal Husbandry has forwarded the bills of the petitioner to the Deputy Commissioner for release. Thereafter, lordship will kindly see, thereafter it appears from the records that on 29th of July 2015, the Deputy Commissioner forwarded the bills along with the certifications received from the District Animal Husbandry Officer to the state government through the Deputy Secretary of the Revenue and Disaster Management Department. So all the bills, the certificates and everything were forwarded, lordship. It is at this stage that the state government, kindly see the language also, my lord. It is at this stage that the state government through the Revenue and Disaster Management Department raised certain objections as to the clearance sought for the bills. Till the stage, my lord, where everything was being done without any objection, no objection was raised, my lord, by the state government through the Revenue and Disaster Management. Only after the submission of the bills, certified by the concerned departments, forwarded by the competent authority, approved by the committee, that they have raised this objection, my lord. And kindly see, my lord, what was the objection that was raised. The only objection that was raised, my lord, was that we have not supplied it to the camps. Now, my lord, in view of the objection taken that we have not supplied it in the camps, and we have supplied it allegedly through distributing the fodder through headmen.
Yes.
On that ground, my lord, the department has refused the sanction. Quoting, my lord, rule number 6.2, which says that we have to supply it in the camps only. There was no averment, my lord, as to the 45 days or the 30 days or the 60 days or the 90 days or anything, my lord. The simple objection was it was not distributed to the camp, so we cannot pay. Subsequently, my lord, as my learned senior has already shown, and similar communications are here as well, that the department had inquired from the concerned deputy commissioner and the animal husbandry officer. In reply, my lord, the incumbent district animal husbandry officer, who was not there when originally the supply order was issued, he has now come and also clarified that there was a miscommunication, it was a bona fide mistake. All the areas of distribution, the names of the release camps, how much, the quantity, the vehicle number, which truck carried how much, everything has been, my lord, submitted, which is evident, my lord, from the letter at page 31. This is, my lord, very similar to the earlier case, my lord.
Yes.
Here also, lordship will see enclosed area of distribution, beneficiary list, so and so.
Yes.
And these are all, my lord, available in the records.
Yes.
So in such a situation, lordship, without taking much time, my lord, that admittedly, my lord, the person who was involved, actually involved in issuing the supply order, who was part of the committee as empowered under the act, under the development disaster plan, it is the, my lord, the deputy commissioner of the district and the concerned deputy district animal husbandry department. And both of them, my lord, have said that yes, this was done with approval after inquiry on short notice. These three firms were identified. They have executed the work as per the supply order. They have raised their bills without any delay. The bills were accordingly forwarded. All the relevant material in support of the bills was certified and forwarded. And at that stage, an objection was raised by the department, my lord, that food was not given through the camps. That was also re-clarified. Now, my lord, to come and say all these other objections is not, my lord, sustainable in my humble submission. And in any case, my lord, lordship will kindly appreciate the list, my lord, which has been emphasized upon at page 23 of this affidavit. This is the same list, my lord, the revised list of items. At page 26, my lord, is the relevant portion.
Yes.
Lordship, my only submission here is, my lord, what point 2 and point 3, lordship will see. One talks about provision of fodder, feed, concentrate, including supply, water supply, and maintenance in cattle camps. And point 3 talks about fodder to cattle outside cattle camps. So in it shows, my lord, that the supply of fodder does not have to be on the cattle camps. It can be in the cattle camps, then a certain rule of procedure will follow, lordship. It can also be outside the cattle camp, and if it is given outside the cattle camp, then the cost of transportation and so has to be done. I am not saying that, my lord, we have supplied outside the cattle camp. As per the record, admittedly on their affidavit itself, it shows that we have supplied it as per the norms in the relief camp itself and not outside, as was communicated earlier by the officer on the basis of a mistake, my lord. And lordship will kindly see that this, my lord, list of items and rates which has been appended, this is not exhaustive, my lord. If there is an emergency or a disaster and it is not possible to restore the disaster, my lord, only on the basis of these rates, it may so happen that this disaster is of such a large scale that these rates which have been notified here have to be exceeded, my lord. In such a case, my lord, the only provision is that, my lord, that those extra rates which have been incurred by the state government have to be borne out from their own funds and not from the SDRF fund. And that is very much part of this notification itself, although it is not appended here, my lord, but that is the position. So it is not to say, my lord, that it only has to be 50 rupees per day and we cannot give 1 rupee more than 50. It is also not, my lord, that it is only up to 30 days and from the 31st day we will pack our bags and go back home. So if this is not exhaustive, my lord, and lordship, I again submit, my lord, that these flash floods which happened in North Garo Hills, my lord, these were not small in nature. It was a large scale disaster, lordship, and flash floods. In fact, I had also seen in the news that somewhere it's called the Great Floods of Meghalaya. So it appears, my lord, that there was a serious issue there. Lots of persons and livelihood and property was affected, and we have given the supply, my lord. Lastly, lordship, on the point of the question of parity, my lord, why I submit, my lord, that there has to be parity in this matter, lordship, because the order by which this was decided, that at the rate of 35 these 3 people will be supplying the fodder, was one single order, my lord. And in that order spoke about 3 firms. One is my firm, my lord, one is my learned seniors firm, and one is the third firm. Now if the third, all the 3 have been given the same work in the same flood, the same item, quantities may or may not vary, my lord. In such a situation, if the third contractor has been paid, admittedly, there should not be any impediment of these nature, my lord, that of technical natures. We understand, my lord, that their last letters say that we will pay once the fund is available. But now they cannot take a U-turn and say that we will not pay because you have not given it to the camp and you have not done it as per the norm and it is delayed. There is no delay, my lord. There is no dispute. Dispute is only being sought to be raised for the sake of raising the dispute. And as such, my lord, this is a fit case, my lord, that all the relevant records are available. Those records will show, my lord, that we have supplied as per the norms. And that is all, my lord.
My lord, the sanction made to the third party were brought on the court by affidavit 5 on 26/6/2000.
Yes,
it is.
My lord,
yes.
The first and foremost aspect is, my lord, what is being placed before your lordship is that one petitioner is claiming 2 crore rupees, another petitioner is claiming 6 crore rupees. 8 crore rupees are being asked for supply of cattle feed purportedly or allegedly ordered by
Mr. Kumar,
the department.
I'll do one thing. It seems you're doing a very important work. You're doing a very important work of compiling your speech. So I'll leave you to a preparation of your speech. We'll come back after lunch.
What I was, because Lord, I will be traveling to Meghalaya today at 3 o'clock, so my flight is there. Lordship may have it tomorrow, and tomorrow so we have this day after tomorrow, or on Friday. Friday we will be with
Friday may not. We'll have it on Tuesday.
So Monday or Tuesday? Tuesday.
Because at 1 o'clock we have a program with the chief.
Yes, I'm sorry.
Heard the counsel for the petitioner. The Leonard AG, appearing for the state respondent, has submitted that he may be allowed to respond to new points of argument or facts being submitted by the party, being submitted by the petitioner. Accordingly, as prayed for, list this matter on 7th. So 7th?
I'll pledge.